Hi, this is Attorney John Cannon with Cannon Associates. And today we're speaking to the issue of, can I get my divorce during COVID-19 or this pandemic? And the answer is yes and no in Oklahoma. For instance, Oklahoma County Court, the surrounding counties, Canadian County, Cleveland County, Logan County, they've all opened up the ability to e-file. So your attorney is able to draft the appropriate documents, give them to you for review, finalize them so they're exactly what you're wanting them to state, and those could be filed electronically in the county courthouse. And the clerk's offices are working around the clock with more limited staff, but working to make sure that everything's filed appropriately, that it's documented correctly, and becomes available on OSC and the Oklahoma Supreme Court Network as soon as possible. We've been filing things throughout this week and throughout the pandemic and the previous weeks to move people's cases, to move our clients' matters along as best as we can. So the first point, filing. Yes, you can file things currently. You could file a petition for divorce. You can file a response. You can file a paternity action. You can file a civil lawsuit. You can file defensive pleadings or things in a criminal case and many other matters. However, you can't physically go into the court clerk's office at this time anywhere in the state. And that's the same for federal court. Now, the federal courts in Oklahoma and across the country through the ECF system have had electronic filing available for years. A great system allows you with your login portal to file things electronically, and they immediately become accessible on the portal. The state courts are just a little bit behind, but now we have electronic filing available in almost any county in the state, so you can begin your case. Next, the point of service. Well, social distancing is an issue right now, and we're trying to be safe, trying to be careful. So there may be an issue with providing personal service against someone with a process server. However, you can still initiate the case by notifying the other party. You can provide them a copy of summons. If it's something that may be agreed, we represent many clients that the parties have just found a point that they're separating their ways and they no longer wish to be married, which is an unfortunate thing, but we're there to help people through those trying times as well. And we're able to draft the pleadings, file them in court, and provide the respondent a proposal, the initial pleadings in the case, and if the parties work out an agreement, then they can move the process forward despite what's going on in our courts, despite what's going on in our country right now. So service is an issue right now with personal service or a process server physically handing someone service. However, we are able to use first-class mail, return receipt, restricted, and we're able to serve things electronically if the parties are willing to communicate with each other. Next, to mediation. So you may not be able to go to court for an initial hearing or for a temporary order unless the court determines that you have an emergency in your case. If there's a health concern, if there's a safety concern, if there's something that the interest of the children in the case dictate that you need to get in front of a judge right now, or a protective order, something else that is urgent matter, then yes, you can physically go in person with us following the proper steps that the courts have laid out, that the administrative orders have laid out, that the presiding judge, whatever county you're in, has laid out. You can go and have an actual hearing. However, otherwise, for non-emergency matters, all hearings are suspended for the time being. However, cases are often resolved without trial or often resolved without a hearing whatsoever. So mediations have been really popular during this time. We conducted a successful mediation last week. It was 6 hours long. It was entirely electronic through video conferencing meetings where we met online, secure rooms that were password protected. My client and his family and I would meet with the mediator. And when our meeting was done, we would leave that meeting room and my clients would return to meet with me. And then the mediator would go to a separate meeting room with the other parties, their attorney, and they would be in a secure meeting room in that place. And then the parties could go back and forth as the mediator was ready for the parties to have their moment to speak to the mediator, which is typically a third-party attorney with experience in family law if you're handling a family law mediation case. And then that mediator can speak to both parties, get their sides, give each party what that attorney believes will happen if the case were to go to trial, if we're to be contested at that point, what a judge may do or what that attorney has seen a judge typically do. And we were successfully able to resolve that case in mediation. That case has been pending well over a year. The parties were at their ends about these decisions about legal custody or who would decide certain matters in the kids' lives, and also the visitation schedule, when the kids would be aware and resulting in the child support amounts. However, through that mediated meeting by video conferencing, we were able to resolve that case. The other party is working on a draft of an agreed order, and we should be able to resolve that case in the next few weeks. So that's just one example. I've got another client we have mediation scheduled next week, and they're the parties have a pretty contentious divorce, and we're hoping that we'll be able to sit down with that mediator through video conferencing, through secured meeting rooms, and try and reach a resolution of that case. So yes, mediation is certainly a possibility at this time, and it's important you speak to your attorney or that you retain an attorney that's comfortable with the technology, that's able to set up these rooms, and has the policies and procedures and systems in place so that they can move through these electronic means and use the technology available to attorneys and family law clients at this time. The next step is settlement. As I just spoke to, the parties can certainly reach an agreement on almost any case, a civil lawsuit, a personal injury case, a divorce, a paternity action, a motion to modify. And if the parties are able to reach an agreement, at least in the larger counties or where we primarily work, Oklahoma County, Cleveland County, Canadian County, which is really the El Reno, Oklahoma City, Norman span there, the courts are accepting agreed settlements by the parties. So if you reach a divorce decree by agreement with the other party, then you can get that order entered, signed, filed with the court, and finalize your divorce. Same thing for paternity action, a custody determination. If the parties can reach an agreement, then a settlement can be reached, the appropriate orders can be drafted, and that can be presented to the court and signed and filed. In fact, today, my office, our staff, submitted an agreed decree for custody, visitation, child support, support alimony, division of retirement assets, a multitude of financial issues, division of property, homes, vehicles, and that was submitted to the judge on our case electronically after speaking with staff. That'll be actioned later this week by that judge, signed, filed in the court clerk's office for Oklahoma County, and then we'll be able to get certified copies of that for our clients and finalize their case, hopefully this week or not next week. So settlement is definitely still a possibility. The courts are still open, but in a limited aspect. Electronic means and some telephone communication is the primary means that we're reaching out to the courts. However, you can still move your case along if the parties are in an agreement. And then that takes us to the last and final stage of the district court level, trial. Trial is the final step when the parties can present their sides, witnesses, evidence, documents, testimony, legal briefs to the judge in a family law case, and the judge would decide that is the outcome of custody, of visitation, of legal decision-making authority and assets, and a number of other issues in a divorce. Unfortunately, trials are being held off on currently in the Oklahoma County District Courts. Due to the pandemic, just the safety of parties and the multiple days that it would take to litigate a highly contentious family law divorce trial, the courts are holding off on allowing those to take place right now. So you will most likely not be able to have a trial, at least in the next few weeks, in most of the courts in Oklahoma for a family matter. In fact, the administrative or chief judge for Oklahoma County came out with an order at the end of last week stating that for Oklahoma County, all civil trials, including family cases, paternity cases, personal injury lawsuits, civil damage cases, they've all been suspended or stopped until after September. There's trial weeks that are set every month through most of the year, but certainly the summer months. And all of those trial weeks, as soon as the courts reopen for regular business, have been reserved for in-custody cases. So in Oklahoma County, at least, until the end of September, people will not be able to have a trial in their civil case, their personal injury case, or family case until the courts reopen to those types of cases being litigated, just to make sure that the people that have been in custody for months or possibly even over a year that had trials set to determine their guilt or innocence have that opportunity before what's considered by the courts may not be less important to you. Every issue is important to us for their clients, but the Supreme Court and the lower courts and the laws have dictated that the right to a trial to determine your guilt or innocence is more pressing than a determination of your civil case, whether you should receive damages, whether you should receive your children, or any other dispute or settlement that comes up in a divorce or another civil case. So I hope that this has been helpful to explain to you, one, the status of the courts right now, and two, what you can do to action or cannot do to action your divorce case right now. Again, the courts are open for electronic filing in most counties in Oklahoma. You should be able to at least provide the other party. You may not be able to get proper service. However, the timeline to respond to a properly served document, 20 days in Oklahoma for civil pleadings, is suspended currently, so those deadlines to file a response are set off anyway. So if it's going to be a contentious matter, it really doesn't matter. You can't serve the other party right now. However, the great news is that mediators across the state are doing everything they can to set up teleconference or video conference meetings. We've been doing mediations throughout the month, and we'll continue to do them to try and reach resolutions that are agreed for our clients while saving them the cost and the heartache and headache of potentially a long-term expensive trial where they can't decide the outcomes themselves. Next, settlements are happening every day. We submitted a settled divorce decree and custody plan today to the district court that we hope to get action later this week. And again, trials are held off for the time being, at least in the district courts in central Oklahoma. I hope this has been helpful for you. If you have any more questions, please feel free to give us a call. Our number is 657-2323. We're always open for free consultations. Feel free to visit our website, jpcannonlawfirm.com, for tons of resources, frequently asked questions, videos, information about all our practice areas, from family law to personal injury to criminal defense. And also, as you've seen at the bottom of this video, as I've been speaking, please feel free to follow us or subscribe to our YouTube channel. We're trying to put out regular, useful content for our practice areas to help you or your family if you're facing any of these issues that we help clients or potential clients with. Again, John Cannon, fierce advocate for families and freedoms, and I hope this has been helpful for you.